There is a name that you are about to start hearing a whole lot. Janus.
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 Janus. Janus.
The Mr. Januses of the world.
Janus is Mark Janus. He's the plaintiff in a case that was heard before the Supreme Court a couple months ago. Janus versus the American Federation of State, County, and Municipal Employees, Council 31. It's a mouthful. But a decision is due on this case like literally any moment. By the time you're watching this video, it might have been dropped. So, here's the rundown. Mark Janus. He's an employee of the state of Illinois. He's a child support specialist for the Illinois Department of Healthcare and Family Services. AFSCME is a public sector union. They represent everybody from librarians to correctional facility employees to nurses to child and family service providers. But Mark Janus is not a member. Regardless, this union represents him, and they charge him what's called a fair share fee, or an agency fee. And that is what Janus is objecting to. When a union is certified to represent a unit of employees in negotiations with their employer, they have to represent that entire unit. They can't just represent the dues-paying union members. They have to represent non-members and people who don't pay dues. And that goes actually beyond just collective bargaining. Things like grievance cases. The union still has to represent non-members in legal cases against their employer, which can cost thousands of dollars. And those non-members aren't paying anything for those services. This is a huge problem for unions around the country. The central question here is not about the popularity of the unions, because it's pretty clear that these employees want the unions to represent them. Here's a great example. Okay, in Iowa recently, a unit of employees certified AFSCME Council 61 to represent them. 83% of the workers voted in favor of the union. 15% didn't vote. Only 2% of the employees voted against the union. This is a popular union. The problem is that only 29% of those employees are actually dues-paying union members. The remaining 71% of these workers are receiving services from the union that they're not paying for. And if they don't have to, why should they? It's cheaper. This is what fair share fees were designed to fix. Basically, the union can charge those other 71% of employees a small fee, a fraction of a union due, just to cover the costs that are associated with collective bargaining, representing these people in court, etc. And it's explicit that that is the only thing those funds can be used for. They very much cannot be used for anything remotely political. Janus's lawyers are making the argument that his freedom of speech has been violated because they say that a union is inherently and inescapably political. Nobody is arguing that Janus was silenced, which is normally the freedom of speech complaint. Everybody agrees that if Janus wanted to speak out against his union, he's 100% free to do so. Rather, they're arguing that he is being compelled to speak, that his money is being forced to speak in favor of unions, even though he can literally speak against them. It's a complicated case. And cases like this one have split the Supreme Court in the past. So everybody's expecting that this case is probably going to come down to one vote. And that vote will probably come from Neil Gorsuch. So unions are bracing for the worst. There are 23 states plus Washington, D.C. that currently allow public sector unions to charge fair share fees. And those states tend to have stronger unions. The average union worker in those states earns about $1,800 more per year than the same employee in a non-fair share state. And as Robert Bruno, a labor professor for University of Illinois Champaign-Urbana, pointed out, it probably isn't a coincidence that the states that are seeing these massive teacher walkouts, like Oklahoma, West Virginia, North Carolina, Arizona, well, those are all states that don't allow their public sector unions to charge fair share fees. And their unions are weaker because of it. What the effect will be on state workers and union workers, well, we'll be seeing that in the years to come. Here's a fun fact. Mark Janus is not the original plaintiff in the Janus case. In fact, it was brought by none other than Illinois' own governor, Bruce Rauner, back in 2015. But a judge declined to hear the case, claiming that Rauner had no standing to bring it, considering he was not, nor had he ever been, a union member. Rauner left the case, but his legal team stayed on, and they're the ones who ultimately found Mark Janus.